Item 23 with personal appearance.
Mention all along. Yes, item. You are the second name. That gadget. Omega. Gadget notification. Notify. Gadget notification. Nobody has they have a copy of that OBC gadget notification. In which month? 23, page number 86. Yeah. Please come to, Madam Secretary, please come to page number 87. How does the department interpret clause 24? What is clause 24 according to the department? No, we don't want an explanation. What is your interpretation? How do you interpret clause 24?
Communities where we are belonging to the garden community or having associated with the garden, but now extraordinary businesses.
Now? But now?
Some garden communities have left the gardens are residing in some villages, nearby villages.
It means that.
Yeah.
Very well. So now who is a OBC? One Arjamala, Asur, Barboi, Baskor, all of them are OBC. No, understand. They are subcategories. This is what we wanted to know from you. Meaning thereby that when you issue certificate to anybody who is a Asur or Barboi or Baskor or Bhutta or Bauri, their ancestors in some manner must be associated with the tea gardens. Does anybody verify that? Who verifies it? And can you produce any record of that verification? Because we are facing a situation when there is a rampant issuance of certificate. Suppose a person belongs to Baudi or Bhakta, the other generation came from some other place and is residing here. By virtue of being Baudi or Bhakta, they are also issued the certificate. This is the trouble. So your interpretation is very right. We agree with it. But where is the implementation? This is the difficulty. All kind of associations and all. Association, you know, they are almost like a private body. Now, according to the law, in Assam, an OBC is a tea garden laborer or ex-tea garden laborer. A Bauri or a Bhakta or a Bhuya is not a OBC. Let the bottom line be clear first. Okay. So now any Bauri or Bhakta or Bauri, if he makes an application, by showing proof that he belongs to this community, you are issuing certificates. This is the trouble. Trouble is a person who is not a tea garden laborer or ex-tea garden laborer are holding these certificates and they are claiming seats. And by claiming a seat, they are depriving one genuine tea garden laborer for whom this law has been made. How do you address the problem?
Now under commission we control all OBC
Man, we don't want those broad-based submissions. How do you address the problem?
under this commission. Now deputy commissioner is authorized to issue caste certificates.
Madam Secretary, we are aware Deputy Commissioner is authorized, they are issuing, but are they actually verifying that they are not?
Now we have got tea garden.
Produce at least 10 records where this verification is there. We'll take it up tomorrow.
So,
At random, all over the state,
one is the public reference is step 1. So we have given the authority to identify the person we should tea garden.
Madam Secretary, we are serious in this matter. I don't know about the department. Produce 10 sample records where there is a verification, where a person of this community, their ancestors are associated with tea gardens or not. Where is that verification? Bring us 10 sample records from all over the state, from any of the district, and we respond tomorrow. Yes, you are the secretary, you send a message to the deputy commissioner. You, whosoever is in charge of the department, ask the person to let the joint secretary come. But whether you go on leave or not, we want an immediate constitution of this Madhuri Patil committee. That is it functioning? No, is it functioning? We want to see there are some matters where there is a fixed time limit for all these determination. There are medical admission matters. I think one of the items is medical admission, where whatever you decide has to be done before 30th of September. No, the whatever committees are deciding, the reports we are getting till now only is that this person belongs to that committee. Or else deputy commissioner has genuinely issued a certificate. We are not on that. No one is claiming any fraud here. Issue is whether you determine the actual determination or not. That is the issue. And we want that this committee should be expedited immediately. The functioning, I mean, existence is there, you are saying. And this decision should be taken, and otherwise the schools are suffering. One Navodaya Vidyalaya is before the court. We are saying we don't know what to do. There is an interim order of the court, provisional admission. We are giving admission. We don't know what to do with the student. And they are very skeptical about the certificate because according to them, the students and their parents does not at all appear to be any tea garden laborer. They do not appear to, but they belong to these 76 communities. It's a serious issue. If there is reservation meant for a particular community of a particular nature, it has to be given the benefit of that only. By giving a twisted interpretation, benefit cannot be given to somebody else. Why? One, that is an illegality. Second illegality is you are depriving a genuine candidate. The person, please take a seat. Why are you standing up? The person for whom this reservation is made, they are not getting it. That's a second illegality. So you can go on medical leave, we know where, but somebody must be in place in the department who will take care of this. You are the secretary. Don't you have anybody higher up? Principal secretary, additional secretary, and all? Sorry. When is he coming back? ask him to immediately get on with your work on from 14th. Mr. Nair, we'd like to have your services here. Because you are having some, on the reservation, we have been noticing you are, just take a look at page 87 of that. Page 87. 86 is that the first page of notification, 87, clause 24. Please read it. How do you understand? Clause 24. Page 87.
Tea garden laborers, tea golden tribes, ex-tea garden laborers, ex-tea garden tribes as listed below.
So there are 76 communities are listed there. How does it look to you? See, what has been done in most of the cases, if anybody fits into those 76 communities, they are issued this certificate. No, it's OBC. Is it the correct approach? Where? Forget about your SC. We are on the OBC 24. So suppose today X is there. The family of X from some state may a generation or earlier have migrated to this place. Tea garden labor community and ex-tea garden labor community, they may not actively be tea laborer as on today. They may also come out of that profession and be residing elsewhere. This is where the two ends are not meeting. In the enthusiasm to recognize that a person belonging to tea garden or ex-tea garden, and I don't know what is the meaning of tea garden and ex-tea garden. If tea garden includes also persons who were earlier associated tea garden, there is nothing called ex-tea garden. It will be tea garden only. So a family, a generation or two earlier comes who had never seen a tea garden residing in Assam. Are they included under this clause 24?
This is specifically to the state of Assam.
No.
So, if you are not a tea garden, either in the family, somebody is.
So, what we feel, so we want your application of mind that what we feel first and foremost, you must be tea garden or ex-tea garden. Once you are tea garden and ex-tea garden, second stage will be whether you are within those 76. If you are out of those 76, still you are not entitled. But merely by virtue of being within the 76, can you become ex-tea garden and get the benefit?
If you are not, originally not there.
So this is what we're trying to ask the secretary, because most of it appears that this exercise is not undertaken.
Because normally in the state, I don't know, the OPC, there are associations, the CSD, there are associations, and people go there. In the rules also, minority is there, provided for.
But
so certificate is taken.
But the association is only to facilitate the process, not to determine the process. Association is there to facilitate the process, and not the sole authority to determine as to who is or who is not.
If there is a dispute with regard to the antecedents of the person, then as Manoj had already pointed out
that whosoever claims will also have to prove it before the deputy commissioner that my father, my grandfather, my great-grandfather, or any of my ancestors was a tea garden laborer in so-and-so tea garden. That has to be proved. Otherwise, it's an absolute aberration.
Not in Africa, in the refuge of time.
Yes, Mr. We were trying to show something. We are reading on paper all along.
There's a notification which says, notification of National Commission for Backward Process, NCBC. There is no single community described as T tribe.
Yes. But there is no multiple community who can be a T tribe without being associated with a T tribe. That is also the part of the law. Otherwise, why do you bring in the term T tribe in clause 24? Make it all 76. Anybody of the 76 are OBC here. There is no relevance of the term tea garden and next tea garden. Then. If anybody out of the 76 are entitled. Now, what is happening, Mr. Nair? A lot of people, the origin of the tea community, they are from a particular two areas. We all are aware of it. Anybody coming from those areas subsequently on their own migrating to the state are now also, by virtue of the common anthropological connection, they are also included. I think this issue has to be gone into, but difficulty is it's very, very time bound because the final decision regarding the claims has to be done before 30 September because otherwise medical admissions. And those school admissions, they are also facing the same problem.
There's a specific quota.
Quota for them. Other day, I think Madam R.S. Chaudhary, she was saying that court is giving interim order, provisional admission, we are repenting, now we don't know what to do with it. A huge queue of the genuine candidates are there. And what is determined is whether the certificate is genuinely issued or not. No one is determining that the certificate is not genuinely issued. It is sealed, signed by the deputy commissioner, and everything is there.
It's a content process.
Whether anybody, so therefore, Madam Secretary, we want some at least 10 sample records. Whether there was any factual verification of this particular applicant being connected with the tea gardens. Unless you do it, you are not giving it to the genuine people, they're depriving them. Any case, because we are little skeptical by seeing the certificate that this exercise is not undertaken. And the committee also, when you decide, you only say, yes, it is genuinely issued. Do you undertake that exercise?
Yes.
That which, please give us one record, which shows that the 2 generations earlier, this man was the tea garden regulator. Give us one record. I don't think it is that. This is why we are telling you, committee is not doing what is required of the committee. Committee is not just an approving authority of the deputy commissioner. It's a huge problem. Thank you. That's why we requested your presence. Doesn't matter guidelines. You are required to follow them. Guidelines are only to aid, and guidelines are not the code by itself. There's nothing beyond that. First and foremost, you have to comply with the requirements of the law. Then comes the guidelines. This is the problem. Deputy commissioners are not doing it. Madam, you are repeating for the third or fourth time, and we are also repeating again with you. Give us one record, where, at least, where there is verification of the connection with the tea gardens. It's not there. At least the ones we have verified till now, we have not found anything of that kind. Only verification is whether this person belongs to the Bauli community. Yes, he belongs to the Bauli community. He should have certificate. That's all. Why? Bauli is included at serial number 5 of clause 24. That's all. The main ingredient of clause 24 that it must be connected with tea garden, that issue is not gone by anybody. So you have to hurry up. You can go leave, but when is the secretary coming? Today is what?
Today is
11. Ask the principal secretary to immediately convene the meeting on 14th on his arrival. Let him attend the Chintan Baitak. We no difficulty with that. But this is also an equally serious problem in the state.
Then I am as an applicant, I go before the committee. Then I go before the deputy commissioner. Certificate is issued. There has to be some, if I may use that word, SOP for that. How to?
No. Madam Secretary says guidelines are there.
But guidelines are there, how it is compliant?
Definitely.
You record.
That much on things. Let us see. Because mind you, had these 76 communities been included in OBC list on its own, this question would not have arisen. You will verify only they belong to the community or not. They are not independently included. What is included is a tea garden and ex-tea garden. And once you are a tea garden or ex-tea garden, then you have to fit into the 76. That's a second stage.
First one is, what is your root there?
What's your rule?
I find out the root. Say my grandfather or my great grandfather.
Anybody in the ancestor was once a tea garden laborer. That has to be. This OM is madam, it's a good OM, but it is short of the requirement of this problem. This is in general, it is okay. But specifically regarding clause 24 at page 87, this is inadequate. When do you list tomorrow? No, for the records.
Records.
No, you don't have to manufacture a record. You have to produce it. You don't have to download. Direct the deputy commissioner to send sample. Sorry. We don't want to see a certificate. We want to see based on what record, what inquiry the certificate was issued. That must be lying in the office of. Madam Secretary, if you are not cooperating, we are going to pass our orders. Let the deputy commissioner remain personally present with the record then tomorrow. See, we are making it easy for you. Let the deputy commissioner themselves remain present. You need not. We don't need your cooperation anymore. Your name, madam? MS Vinita Pebu, the Secretary to the Government of Assam in the Social Justice Department, is present before the court for an interaction on the interpretation of clause 24 of the Gazette of India, the notification contained in the Gazette of India dated 13/9/1993. Clause 24 of the said notification pertains to the list of OBC applicable to the state of Assam, where clause 24 is inverted comma tea garden laborers, comma tea garden tribes, comma ex-tea garden laborers and ex-tea garden tribes, as listed below. In the list of the communities pursuant to the as listed below, the name of 96 communities are made available. We require the secretary of the department to give an interpretation as the department is following. And as the department is giving to clause 24. As to whether any person belonging to the aforesaid 96 communities would be OBC under clause 24, or there is also a pre-requirement of determining whether the applicant or any of his ancestors were earlier associated as tea garden laborers or are also presently continuing as tea garden laborers, and thereupon examine whether they belong to the 96 communities. A reading of some of these certificates issued, which are subject matters of dispute in this petition, it prima facie appears that the determination may be only in respect whether they belong to the 96 communities without the pre-required determination as to whether any of the ancestors or the applicant themselves are tea garden laborers. To verify the same, 10 records of 10 of any OBC certificate under clause 24 that have been issued on a random basis be made available to the court tomorrow. The respective deputy commissioners, on the discretion of the secretary, who are required to produce the records, be personally present before the court along with the records for examination. List tomorrow. Any difficulty? No. We requested Mr. U.K. Nair, Learned Senior Counsel, to act as an amicus for assisting the court. A copy of this order be made available to Mr. R.M. Das, Learned Counsel for the Social Justice Department, as well as Mr. P. Saikia, Learned Counsel for the respective deputy commissioners, for doing the needful. Just from yourself, ask them to pick up the records of any matter. And we are giving it a broad-based one. He can be Deputy Commissioner Kamrup Metro, Deputy Commissioner Dibrugarh, anybody. We just want to examine whether this pre-verification of being connected with the tea garden is done or it is not done. If it is not done, we are required to pass some order that it is required to be done, so that the committee that will set from 14 can actually undertake this exercise. And if it is done, it is well and good. Then the issue does not arise at all. Or records, including the records of the certificates issued in this 3 writ petitions. Just verify the particular record. Ask, please send us the record, how it was issued. That will serve the purpose. Your personal opinion dispense you. Just ensure that this we have this material for us. The common order in all the 4 or 5 petitions. You do whatever you, we have to determine your caste status, that's all. We don't know.
I think one promotion.
Regarding. So you withdraw the suspension. Any review done? But this is a motion. Can we disclose it or? It's only it's an oral submission. Your name, madam? You heard MSP Goswami, then counsel for the petition, also heard Mr. SMT Chesty, then counsel for the respondents in the secondary education department. Mr. Girin Prabhu for additional for respondent number 3. An order dated 14/3/2023 of the Inspector of Schools, Silchar, CBSE Silchar, whereby the petitioner, because Purakasta was placed under suspension, is assailed in this petition. It is noticed that a period of 3 months since the order suspension is already over. Accordingly, we require the information from the respondents as to whether, as required under para 21 of the judgment of the Supreme Court in Ajay Chaudhary versus Union had been complied with or not, it had been reported by Mr. SMT Chesty, the counsel for the secondary education department, upon obtaining instruction that no such exercise or review had been undertaken, nor any show cause notice had been issued against the petitioner. I think we have Mr. Nath. I think it's Mr. Nath. Who is outside? Mr. Nath.
Inform that no such exercise of review has been undertaken.
As required under in view of the premise given made out, the order of suspension is taken until further orders. Issue notice returnable 4 weeks instead of its just prior to this, there was a serious matter going on regarding whether a person is in Tea-Garden Road. Why is the officer conferring with the petitioners outside? They can see it from here. No problem. Instead of officer, we asked the officer's presence on behalf of the respondents. There is no business to confer with the petitioners. It's been going on still. Ensure this doesn't happen. Certain things should not be done.
Item 2.
Here's item 2. Same.
Same matter. So, madam, now thing is that it is now already before the committee matter. We will legally time matter because we have sent it for this very vigilance committee matter.
No, now again you represent or Mr. Das
So
represent.
this is for the KD, tribal affairs matter.
So this is your
So this is my
OBC is the other.
This is Mr. Das. I am with the tribal.
Mr. R. Dhorland, Council for Respondents in which department? For the Tribal Affairs Range Department, praise for. But this is the medical admission. Everything has to be complete before the 30th September. Hmm.
I know because this secretary is the, because she has to, I will just, she's there, I will just get some. I'm not sorry.
Otherwise, no, we'll let me know.
Item 3.
Sorry. School documents.
Yes.
What correction?
Yes.
No, yes, I know. What correction? No, we don't want. Which document is to be corrected? Page number?
29. 29.
What correction you want? In page 29, what correction is one? Krishnamgowda. Now what correction? Sorry? Instead of father, the uncle's name is there.
Yes,
What?
because the mother was died in the year 2008.
Okay, he's an orphan under the guardianship of the uncle.
At that time, the President Krishna was at the age of 8 years. There are the family.
CBSE. Where is Madam R. Bora, CBSE? Understood your point. Please wait for some time. Let Madam Bora come. Ask her to look into. List allowing showing the name of MSR Bora, then counsel for the Central Board of Secretary. We're listing it the day after tomorrow, Wednesday.
Item 4.
Yes, Mr. Gogoi, B. Gogoi. Medical admission. Yes, Mr. Gogoi, what is to be done?
But there is a instruction from the medical council. If there is any disability in the hands, both in front one hand, you will not fit for medical. I got the report, but then guideline immediately after some time. Otherwise, it is. But the disability.
What you mean in the college? What is this? 40% in relation to left hand. Mild left ankle stiffness. Deformity in the left. So this nature of deformity, medical council says you cannot admit, right? But to be a doctor, you need both. Suppose then what kind of locomotor disability is accepted? Leg will be accepted. So he'll be taken by a wheelchair by somebody and he can diagnose the patient. But how can we determine that?
This is the one of notification of the Board of Governors is quite.
Terms are usually used instead of physically.
Also, you see the chart,
Type of disability. That's it.
down below, the start, board and intellect.
Person with visual.
So after the chart, board and intellect with intellect sensation.
Very. Acha, that triple asterisk.
Yes. Board and intellect with intellect sensation, sufficient strength and range of motion are essential to be considered eligible for medical.
The petitioner does not fit this.
Which part is that? For medical course, these are less. He has shown me that his hand is intact, he can get the speed, move his hand.
No. Both hands intact. That is okay. You are right. With intact sensation. Maybe that only medical expert can. And sufficient strength and range of motion. Mr. Gugui, we cannot determine this. Ask him to be placed before an expert board. We will assess about the intact sensation, about the sufficient strength and range of motion. And if they certify that he is good enough, give him. If he certifies he is not good enough, you have to face the consequence.
Then you have to appear before the orthopedic department.
Orthopedic department.
The direction to pursue picture they have-
Yeah, otherwise we can't determine, yes.
He may reject them, because this was done by a person with a counseling process.
So this will be a specialized diagnosis or regular. Your name? We are sending it back today. Itself.
Yes.
Otherwise, time is very less.
Hospital as the principal PMC is to
To constitute a specialized medical board comprising of orthopedic experts
and any other department.
or any other as per the discretion of this principal. Neurology also, yes, maybe. To assess this particular aspect. Your name? And heard Mr. N.H. Loskar, then counsel for the petitioner, also heard Mr. B. Gugoi, then counsel for the health department. Sorry? Okay. We put it. The petitioner Muhammad Shahin Shah Alam, alias Shahin Shah Alam, has instituted this writ petition seeking a direction to the respondents to consider the admission of the petitioner under the PWD quota in the ongoing admission to the first year MBBS or BDS course in the Government Medical College and Dental Colleges of Assam for the session 2023. The petitioner is assessed to be a physically disabled person who had assessed it. Mr. Gugoi, who had made this assessment? No, this one. Every has been examined by the medical board constituted to assess the physically disabled persons. We were considered in the Guwahati Medical College and Hospital to assess the physically disabled persons for the purpose of admission to the first year MBBS or BDS course. The report of the medical board as produced by Mr. B. Gugoi and counsel for the health department is that the petitioner had been assessed to be suffering 40% disability in relation to his left hand, where it is also provided where the medical opinion is inverted comma GD4. Fixed abduction, is it abduction? Abduction deformity hyphen left thumb semicolon MP joint of left index fingers stiffness, weakness of grip, strength semicolon mild left ankle stiffness. Mr. B. Gogoi Lankan Health Department opposes the prayer in the writ petition by relying on the amendment notification dated 13/5/2019 of the Board of Governors of the Medical Council of India, which provides that if the physical disability is within inverted comma, it is 33 both hands intact with intact sensation, sufficient strength and range of motion are essential. Medical opinion regarding the disability of the petitioner do not satisfy the requirement of having intact sensation and sufficient strength and range of motion for being eligible for a medical course. We perused the medical opinion rendered by the medical board constituted in the Guwahati Medical College, but a reading of the medical opinion doesn't make it discernible that that an examination had been conducted with regard to one inverted comma intact sensation and one inverted comma sufficient strength and range of motion comma in respect of the petitioner. In view of the above, the ends of justice should be met upon the petitioner being placed before a special medical board comprising of experts in the orthopedic department as well as in the neurology department to make an assessment of the petitioner regarding intact sensation and sufficient strength and range of motion as to whether his disability, as to whether the nature of his disability would disentitle him to admission in a medical course, or in spite of his disability, he would still be entitled. As it is a matter of medical admission where the last date would be 30 September 2023, we direct the principal of Guwahati Medical College to constitute the aforementioned specialized medical board with experts immediately and not late, as agreed, on 18/9/2023, and for the purpose, the petitioner shall appear before the principal of the Guwahati Medical College at 11 a.m. on 18/9/2023. Depending on the outcome of the expert medical opinion, the entitlement of the petitioner for an admission to the first year MBBS or BDS course would be determined by the authorities.
Item 5.
There were 2 orders from this on the court.
Is there any urgency, Mr. Nair?
No such urgency. But it begins there are 2 orders. There was a is rejecting, they consider two committees.
So VC allowed, EC rejected.
No, मतलब EC considered a committee to examine it. That committee recommended nothing. Chancellor writes, give it to her. But the EC on one or the other count rejecting. That's the case.
What is the claim for say admission?
No, she was to be a reader in 2002. But the cutoff date is 31st of March 2001. She should be 6 years of service. She had 7 days less as on 31/3/2001.
Regarding your past service of 2000. So now if we decide in your favor, what will happen? Already retired.
No, she's in service, she's on the verge of retirement. Let them file that affidavit, my lord, we'll have it next week.
But Mr. Again, I am a counsel for a petition, also heard Mr. PJ Pramod and also responded in the health department.
What do you
Anybody else? No.
All the rest.
Issue notice, returnable 2 weeks, the respondents to file their affidavit objecting to the claim of the petitioner, as may be advised. On the next returnable date, an endeavor shall be made to give up and consideration in as much as the issue is within the narrow compass as to whether a 7 days period ought to have been condoned in the year 2002 to make the petitioner eligible to be a reader in the department concerned, or whether the 7 days time could not have been condoned. It is stated that a committee constituted by the Executive Council of the university had recommended in favor of the petitioner, but the Executive Council for some reason is Executive Council for some reason is not accepting it.
Item 6.
Yes, Mr. Saike. Yes, because the total mass for 60 and 79, it should be 2 according to you, not 4.
On Friday,
You are feeling pretty responded.
I am body private.
I'm for the department.
So we are given 2 marks more. What do you have to say?
My lord, I don't know how, my lord, what has happened.
Mr. Saike's one name of argument is if the percentage of pass is between 60 and 79, you are entitled to 2 marks. Okay.
I was given 4.
In the given school, the pass percentage is 76, so you should be given 2, but given 4.
And there is one more, my lord, that I was the in charge principal for 3 days, I was given 1. So that has also to go.
In the same category.
That's the same category. These other.
Okay,
other
for
point
being in charge, you get 1 more mark.
No, I don't get that because I have not completed 1 year. I have only done for 3 days. So if
She
that
did.
goes also, then we both become equal.
Huh.
70. And if we become equal, if that marks goes, then it will be my lord.
Your age.
Or the date of joining.
Uh-huh.
Either way, I'll be there. That's my.
Two mark goals will become equal. If the another one goes, in that case,
Another means which one?
that actually is standard. See what the point is whether the church after the last day of application, and just 3 days before the other interview.
So that part will also go.
That was also written. 17 I'll be agreed.
Yes, Mr. Nair and Mr. Sharma, he said your 1 mark will also go.
Well, I've been told that the state selection board has given both of us 77. I don't know how.
So now, Mr. Saike, your both the challenges are gone now. Because ultimately you are equal because you have also been brought down from 18 to 17. So you now find a new repetition challenge that how you have brought down from 18 to 17.
Third category is also there.
Third, again third. What is the third?
Administrative capability, administrative ability. We have been given
No. Both your contention that he is given 4 marks instead of 2 had been accepted by them. Your 1 mark more for in charge that should not have been given, that is also accepted. After accepting both your contention, both of you are 17, you are not 18. This is what the record reveals, if I understood rightly.
given the RTI the marks. They are given 18, will be given.
Then what to do? We issue notice.
And the third category.
No, we issue notice. What else to do?
As far as school slates on board, states slates on board, so they're not.
Mr. Senior Counsel, issue notice returnable on so and so. The respondents may file their affidavit. The records produced may be retained. Retained. Do you want to retain all this? You can be retained. Any promotion that may be. Be retained list of next Tuesday for a final consideration. Inasmuch as the records reveal that both the writ petitioner and the respondent have been awarded 17 marks each. Records are there. Mr. Saikya, we also allowed to examine the records. Examine the records. We'll hear you on the next Tuesday. Interim order till next Thursday. Okay, next Thursday.
7.
There is some improvement regarding the notification of correction of the right color.
The new part.
They are having a webinar today with Kanipa in order to resolve this. Last order is that now
It is stated by Mr. B. Gogoi, Learned Counsel for the SSA, that an webinar with NIPA is scheduled for the day, wherein the issue involved would be given its consideration. In view of the above, list on Swiss.
resolve the issue.
All that. Next week. Next week. Next week.
21st. Item 8.
Yes, Mr. Hussain. Only you have. What? Department. Where is the DLC? 20? 20. So now, SLC. What happened to in SLC?
What has happened is that this DSC has referred to investigate commerce department.
No. Recommended.
Yes, recommended.
Recommended is recommended. There is no reference.
Yes, Lordship. Now, the problem is that now if there's something process, there is a case which has come before this court. And in that case, I would say there is a finding given by this court saying that
In this matter,
not in this matter, in another matter also, I just replace this case now because that is a legal point issue involved there.
what kind of legal issue?
So now also for a case, if a person died in birthdays, his sons or daughters, I mean, which notification will be applicable in the particular case? Which date will be taken as the date of application and the date. So at that point of time, which notification will be applicable that has been decided by court date based on this honorable court.
Which notification will be applicable?
Now, in this case, what has happened also, this person has died on 4/1/2013, and application was filed on 22/5/2013. So at that point of time, also the notification of 2015 was not there. So in that,
Mr. If you go to NC Santosh, paragraph 35, norms prevailing on the date of consideration. So that Supreme Court clarified the whole thing.
so
No, we did not produce. We have
we have
to
discussed about all these things.
understand.
They come to a finding that on the date of the death,
I think
whichever the application or notification is applicable, that will be taken as the very next.
no. One is NC Santosh and the other one is Malananda Sethi. Two different principles have been involved. Regarding the applicability of the scheme, Sethi says one at the time of death or at the time of application. Okay, scheme. The Santosh used the language criteria, those criteria prevailing on the date of consideration. So now one judgment had already been rendered reconciling the two judgments of the Supreme Court. If there is a question of entitlement for compassionate appointment determined by a scheme, then it will be the scheme that prevailed as on the date of death. Okay. But if there is a question of the which criteria to be followed, then date of consideration. NC Santosh. We give due respect to both the judgments of the Supreme Court. Now, following that, the criteria is prescribed in 2015. Consideration after 2015. So we go by 2015. Legal issue is, that's how you have to look into it.
So then, Lordship, should notice that the police are in public, whatever the instructions they have, why you must consider, and like other things also.
No, we don't issue notice. You bring it to us, we'll consider it. We have it next week. Give you time for that. Because compassionate appointment, if we issue notice, matter of another 3-4 years. So what happens to the compassion? It will evaporate due to the passage of time. So let us take it up. As you want to examine, we definitely will give you time. Just in the next week on the prayer, Mr. Ekalita, then comes up for data.
Paragraph 8 also in the case.
ANC Santosh. para 19, applying the law compassionate called out. Our opinion on the issue is that norms is the word. Norms prevailing on the date of consideration. So when it is a question of norms, it is date of consideration. And Shetty people and Mr. The other day what we expressed, even Supreme Court says, even after such a direction, if frivolous or vexatious reasons are given for rejecting the applications, we would also take note of that. Avasti percent.
Two cases have been referred in this case also.
Avasti and Santosh is not
They
right.
have been discussed. But other
Only
cases-
that the Vimesh and Bhimappa, that is on another issue. Para 10 of scheme circular prevalent on the date of death of the deceased. The scheme date of the deceased. Okay. Once you are entitled under the scheme, what norms? Date of consideration. This is the only way we can reconcile Santosh and Avasti. Because there was, at one point of time, there was a huge confusion. Somebody realized that Santosh said this, somebody realized that Avasti says the other one. Then we are compelled to take up both in one given case, and I think there is a judgment. Reconcile between the two when it's a question of which scheme is applicable, date of death. Because one case had come that on the date of death, there was no scheme available for compassionate appointment. There, the Avasti will be applicable that if on the date of death, if there was no scheme, you were not entitled to compassionate appointment. But once there is a scheme, you are entitled. Which norms to follow?
Date of consideration.
Santosh.
Order still vacating as if 9.
Yes. Which state to be vacated? You are for the writ petitioner. Mr. B.D. last and City Council for the writ petitioner praise for. In the meantime, 226 will be applicable against. Praise for 2 weeks time to file affidavit. Then we'll have to, today we'll have to hear him. Mr. To continue, we'll have to hear Mr. Doctor today. Otherwise, ultimately we are hearing the matter. So if you want only an adjournment to file affidavit, we'll grant you. But we'll not observe anything, silent. Neither this way nor that way. And on the next day, we'll determine. But if you want a positive order to continue, then definitely Mr. Dutta has to be heard. Because today he is present. It's, want a fixed date or open?
I think there is for admission.
Fraud between the fraud. Adjourned on the prayer of Mr. E. Gogoi and Council for Higher Education to be listed on.
Item 11.
Then it is for a petitioner.
Item 30.
Arbitration. No, this is a petition under which provision? Under section 11. What does section 11 say? Section 11 says when the possibly when the parties fail to appear, arrive at a conclusion. So your view no longer, your GCC is no longer is not relevant anymore. Who will appoint? Madam Chakraborty, by insisting on that, you are reiterating that give us the power to appoint the arbitrator, which earlier had failed. So only when you fail, section 11 petitions are filed. We'll take it up next week. If both of you have any arbitrator in mind, tell us. But both of us to agree to it. And if not, we'll appoint next week. List in the next week for appointment of the arbitrator. The parties may make their suggestion if so advised.
25th September.
I don't have further point number 5.
Yes.
Item 14.
Yes, Mr. Gurinder. You want time? MSR Dekha from the respondent Assam University Press for 2 weeks time to file affidavit. List after 2 weeks.
15 to 70.
15 to 70. Yes, 15 to 70. You want to file affidavit? Mr. K. Gogoi, Heritage Press for how much time? 2 weeks time to file affidavit. Item number 17 of it. Otherwise, it is tied up. On this call.
18.
18 years. Yes. Page number 36. This is under the 2011 Act. But that act is no more, it is set aside. Who appears for the respondents? This is a secondary education or secondary? We appear, Mr. Sharma? What do you say? Or Lisa Pansy? Lisa Pansy. Mhm. Yes, Mr. Sharma, what is your submission? Page 36. There is a employees found eligible for provincialization under 4.1, Saiful Islam, serial number 7. Mr. Sharma, are you prepared with the matter? Please come prepared. We can't allow you to prepare your argument in the middle of the hearing. If you do that, somebody else will be affected. Next matter. And adjourn on the prayer of Mr. U. Sharma, line for the Secondary Education Department, to be listed.
19,
But Mr. Sharma, this little a legal issue is involved. Please come prepared. This one, page 36 is dated. What is the date? And you read the High Court order in page 44. Mr. Chisti, this order in page 44, it has survived or it has gone in appeal? Because this one also looks almost the same. Because if you come to page,
But in other cases, post will not sanction.
no, there is the 2011 Act does not require any sanction of post. Posts are sanctioned by virtue of the promulgation of the Act itself. Okay. Now, all that is, Dilip Das had held that if somebody is found eligible, he is deemed provincialization. And page 36, please look at it. Page 36, just look at it. This man also is found eligible under 4.1. Only thing that administrative order is not issued. And we have held that administrative order is not relevant. 2017 Act administrative order is relevant.
But here, it is not already one of the formal office. The person whose services are not regularized as a Militant Act.
Those who is not regularized. This is a case where it is deemed regularized. There's a difference. We'll hear you next week. Please come to tell. I think let me. There is a difference between the 11 Act and the 17 Act. 11 Act says those who are eligible and fit into that schedule. Suppose X school has 2 teachers and 2 teachers were found eligible. Their services are deemed provincialization. It's a legal fiction. The language of 4.1 is such. But the language of 4.1 in 17 Act is different. Here you need a formal administrative order. There's a difference between the two. So, under the 11 Act, the law itself has provincialized it. Next week.
22nd.
You also come prepared.
19.
Read the 2 acts and make your submission. 11 Act and 17. But 11 Act, if somebody is not processed, then what you are saying is right. No. Second word we are having. Second word has to be given the interpretation. If you read the language of section 4.1 of 11 Act, it's a deemed provincialization. So law had provincialized them. So they are regularized. And mind you, Mr. Chisti, your legislators are aware of this lacuna in the 2011 Act of deemed provincialization. You don't need a formal order. Only thing, you have to make an assessment whether this man is within those sanctioned posts or not. That's all. To remove the lacuna in 2017, you notice the language has been changed. After the court has given this interpretation, language changed in 2017. Now you need a formal order. So the legislators being aware of the difference, now you cannot give the same meaning of 2017 in 2011. Now it is there. Earlier it was not there. Thank you. Thank you. Mr. Chisti, earlier occasion you paid 4 weeks time to file the affidavit. Your name is there. One time. And consumer said, please for the how much? For weeks time. Please update.
How I selected as the assistant professor, since we still
No, today what is to be done? This is appointment of that's for appointment of what?
assistant professor.
Sanskrit.
But the option is that based on the verification of her now, as for my instruction boxes, of the verification, her disability has been found 52%. So the
And what is the assessment according to you? So you have made the assessment, send it to the higher education department. No way appeals for higher education. Yes, but Mr. Das, person is selected, you send for re-verification of the physical disability. The report is that 52%. Now you act upon it. Why do you keep it pending? List on switch so to enable Mr. S. Das and Council for Higher Education Department to inform the court as to what further had been done by the department as well as the college authorities pursuant to the selection of the petitioner after the report of the medical board had been transmitted to the department. This next week. 25 to right, communication dated 25 to 20. Medical board will communicate 25 to 2023.
Item 22.
Have you filed your affidavit? The Mr. U. Sharma has answered for the second place for how much time? 3 weeks time to file the affidavit around just after 3 weeks.
24.
24. Mr. S. Bottabul and prisoners placed for 3 weeks time to file a reply to the affidavit of the respondents.
25.
5 years, Mr. Son. No affidavit has been filed. Fine. It's not on record. No, we don't have it. And Mr. Phugan, does the department want to file? You are
Issues related to enrollment of the student. That has to be placed by the SSC.
see, if you want to file, you file. We give you time. If you don't want to file, we record and say up to you. That's again a vague no if required. Either yes or no. You want to file, Mr. Phugan, for the elementary. Please for 2 weeks time to file affidavit number. It is stated that the affidavit of the SSA had been filed, but it is not on record. List along with the affidavit.
26.
Adjourn of parent Mr. B. Children and Constable PTC.
$29 for order.
None appears for the petitioner. List again.
Item 30.
30 years. Respondent number 3. Sub Dusty. You have filed affidavit. Page 50. By which order Dusty was allowed? By the order dated 3/3/2022, the petitioner was allowed to serve Dusty on the respondent number 3, being the governing body of Bilasipara College. An affidavit has been filed by the petitioner enclosing the copy of the notice, which contains an endorsement of being received by the principal in charge of Bilasipara College. In view of the Above, service or notice on respondent number 3 is accepted. After how long you want?
31,
None appears for the petitioner. List again in the event of subsequent non-appearance, appropriate notation for it.
32,
Yes, Mr.
I have to complete it.
Sorry,
Service hasn't completed.
there's office code. It's a deemed service or actual service? It's a deemed service, postal consignment. Take residence. What will happen once you pass an order in your favor, that man will come and say, I never received notice. So everything will fall through. If somebody appears, it is okay. No, for respondent number 3 and 4. Does he appear? If he appears, it is okay. Mr. Chaudhary for 5. UK Nair is there, name is there, but we don't know for whom he appears. Please do tell us. If it is complete, if it is not, postal thing ultimately is not fruitful. Legally, yes, but purposefully doesn't mean anything. Yeah, next. Next. 33.
33,
Just check up and tell us. 33 years. In Francis. Your name? M. Ahmed. Mr. M. Ahmed, then counsel for the petitioner states that the matter has become infructuous and does not require any further adjudication. In view of the statement, repetition closed. You appear for somebody? For whom? In terms of that appear for it, appears for somebody. Any interim order you can stand begin.
34, 35,
Yes, Mr. Decker. That tea auction center. What happened earlier?
Elections were scheduled, but thereafter it has not concluded. Perhaps the senior council is taking up to dates, but it has not.
So we adjourn it today. Mr. B.D. Decker, and counsel for the petitioner, as well as Mr. A. Biswas for the respondent, states that certain steps have been taken for holding the election, but the elections are yet to be concluded. In view of such statement, list after 4 weeks.
By this time, steps. By this time.
Well, there-
It was scheduled on 8
I know.
February.
So with this, after 4 weeks, you tell us what happened. If nothing happened, we'll hear it again.
Over the night.
36,
6 years or 7. Mr. D. Royal and counsel for respondent Seva prays for 3 weeks time to file affidavit payroll this after 2 weeks.
37,
37. Yes, madam. No, today what is to be done? That is your grievance. Today what is to be done? Aji ki kori? Can we hear you finally or?
What has happened from the order is that the order report that the petitioner thinks that the National Medical Commission be treated. So on earlier occasion, National Medical Commission is treated.
As Chakraborty is permitted to impede National Medical Commission. by hand in presence of, you've done it.
Yes, started by.
And steps taken, served.
Receiving of this file, or I can get it on behalf of the-
You are it. Your name, please.
DK Boyko.
Mr. D.K. Boydell and Council enters appearance for respondent number 5, National Commission for
Medical commission.
Medical Commission. And praise for,
Why not, we next week, why not, because the rules are very clear.
praise for a week's time to file affidavit.
Why not, instructions, that suffice.
No.
Affidavit, then 2 weeks, why not from there?
2 weeks time to file it. Yes.
26 September. Item 38,
38. One time granted to the petitioner to take steps. Have you taken steps? Those. Await service report as per the office note dated 7/9/2023.
39,
Madam Bora, today one matter came. Item 3, we have ordered to be listed day after tomorrow because item number 3. Name is also we know, that's why we had it 10. Day after tomorrow. No, this is just look into it. If you have a copy with copy that did you go here, one orphan is there. Okay. Both mother and father died. The orphan lived with the uncle. The name of the uncle and the aunt is shown as the name of the father and mother. They want to correct that. I think we have to look into it. Even the school records may be wrong. But don't take those technical objections. Use your power to correct it. Because now the orphan wants that the actual mother and father should be depicted. I think you can look into it and pass some order. Yes, sir. Dusty, no. Dusty. Contempt there cannot be dusty. Contempt and criminal matter there cannot be dusty. Understand? Maybe due to oversight. But he had taken steps. But on the basis of this one, we cannot send a man to jail. Who is he anyway? Who is the? I think you can take note of it. Mr. SMT Chisti, when comes Standing Council, take note, and also states that he would appear for the responding contender, being the Director of Secondary Education. Both, I think against both Director and Inspector. Give him a copy, he will appear and we will record it.
40,
Then he appears for the petition of listing.
41,
How much? Mr. K. Goyal, for a high praise for 2 weeks time to file a paper. Just after 2 weeks. It's a contempt. It's a contempt. Which contempt? It is for them. How can we No, for implementing the present incumbent, it is your discretion. If you want, you file. If you don't file, and if the necessary party, we may dismiss the complaint later on.
Fix the date and amendment will be-
Madam Tarun, the day you file, it will be distant.
32.
Notice yet to be issued. Where is the direction?
Direction was you find the page 12, the last paragraph.
And communicated.
3 months.
Communicated. No, have you communicated?
Yes, the next.
YS Chavan, YS Mannan. 6 weeks, notice register post 3 days.
43.
M. Rahman. None appears.
44. Item 44.
You list again. Let him make a mention. Paste number. Appeal file. Your name? MSU has already got 6 weeks. Notice 3 days. Rest of it.
45.
This is Mr. Islam.
19.
Communicated.
Yes.
Check.
46.
Answer script of the minor court. Have it. Why did we pass this order? What you?
When C4 1 went for verification, as per the guidelines of CPS. Upon verification, what they observed in 3 papers, the first page of few pages are there, the other pages were gone. And they are saying that
No,
done so.
let us take a look at the. No, let us take a look at it. How it is done. Who it from.
Wait on she is saying, but in this they do not know, we see only roll number is written on the answer sheet. The CPS also, they all immediately they back and seal the book and send it to the central lodge.
Where is it done?
Lodge it by mark is marked the recordings.
This part.
No,
It is not considered. Pragma is real logic. It's not prejudice. Pragma is real logic. Pragma is real. And the report of the reviewers, they immediately when they examine the answer, the report has been given in the answers to itself.
Where is the endorsement of the invigilator that it was given in the term condition?
So that is not here, the report of the, actually the.
Let us take a report.
Let
Let us look at the. Let us.
Like and the outcome report is here. When the comments are asking from the.
And this happened in how many answer sheets? All four.
All four and mathematics also not found out.
Where is the mathematics?
Yes, four actually answers I had given. Mathematics.
This is the
In each examination, yes, about only 25 marks, 8 marks, 6 marks like this. Yes, or
Not up to date. It's not gone through the record.
mathematics with answers with plus. But thrown out by all the now see
We are seeing that.
now
Can you say that?
now they are
But
eliminating
even
that
if-
mathematics
Then
examination answers does not belong to higher. What is the complete handwriting? Same handwriting.
Same handwriting means?
Anything that mathematics, their answer sheet does not belong to the actually functional's daughter. Consider can be verified in handwriting. Same handwriting logic. Or it will be
Heard Mr. G.
determined by the-
Boschel and counsel for the petitioner, also heard MSR Bora and counsel for the respondents in the Central Board of Secondary Education. This writ petition is filed on an allegation that the answer scripts of the petitioner had subsequently been torn by someone, which resulted in the writ petitioner getting less marks than she otherwise would have been entitled. MSR Bora and counsel for the petitioner, as ordered by an earlier order of 38/2023, has produced the answer script of the writ petitioner in origin. After perusing the answer scripts in origin, it is the submission of MSR Bora that it is the writ petitioner herself who had torn some of the pages before submitting, which was later on detected by the officials in the CBSE when the answer scripts were examined. Were examined. See, Madam Bora, your one word disturbs the whole.
Sorry.
You can add any number of words you want at the end of the order, not in between. You go ahead.
After perusal of the answers to the submission of MSR Bora, that it is the writ petitioner herself who had torn some of the pages before submitting, which was later on detected by the officer of the
By the authority undertaking the examination and of the answer scripts. It is stated that the same attempt was made by the petitioner in the mathematics paper also, but the pages remain half torn and the petitioner could not succeed. On the other hand, Mr. G. Boissel and counsel petitioner states that it is absolutely illogical on the part of the petitioner to tear her own answer scripts, and therefore the submission of MSR Bora should not be accepted. In view of the conflicting stand, we direct the state CID to make an inquiry and submit a report before the court as to which of the two stands are to be accepted. The answer scripts in origin produced by MSR Bora be kept in the custody of the registry to be handed over to the CID for its examination.
Yes, giving the compartmental examination also.
No, that you do, that is follow. We are not interfering with that.
Yes, not it.
This after 4 weeks, Mr. Can you hand over it to the CID or we need Mr. Nath? He can do it. Mr. P. Boraland, P. Second and judicial advocate is informed about the order of the order requiring the inquiry to be made by the state CID and Mr. Sakia to take up with the appropriate authorities for doing the needful. Upon the appropriate official of the state CID making himself or herself available before the registry, on being identified by the learned state council, the registry to hand over the answer scripts kept in its custody to the official of the state. This after 4 weeks. A copy of the order, Mr. P. Sakia. Formally take custody. It's a writ petition. Notice is already issued. Today, what is to be done? Elementary education. You want to file affidavit. Mr. Ganesh Pegu for the elementary place for 4 weeks time to file affidavit. This after 4 weeks. Interim order to continue.
48.
ADBSA Khalifa. Mr. Chisti, SMT Chisti. Secondary education. Chisti Secondary Education, R. Gaur, Accountant General, A. Chaliha, Finance Department. For anybody for the secondary education, you are there. Yes. What do you want? You want to file affidavit or not? Mr. U. Sharma for the secondary. Adjourn order prayer, Mr. U. Sharma, then comes the secondary education department to be listed also and so to examine the sub contention of the council for the petitioner that the matter is covered by the order details so and so in the PPC so and so. Next.
49.
Mr. Decker.
And in this case, I am appearing on behalf of Rajput number 4.
You change sides. Okay. You want to file affidavit? Do you want to file affidavit? David, I was responding for praise for how much time?
7 days.
7 days time to file affidavit. Prayer now this after 7 days. You want to file affidavit?
Not 7 days.
Mr. S.
Actually, what happened, madam, this case, let's put the appointment of the headmaster. In this case, madam, I was working as a headmaster before position of the school.
She has urgency.
School has been amalgamated with me since my
Okay, we'll hear you.
has no BA.
We'll-
So he approached the summer.
Madam Devi, you file your affidavit with
Yes.
hearing up just after 7 days.
After 7 days.
In the meantime, state respondents may also file their affidavit.
I have like.
Interim till next date.
Item 54, girls.
What's your name? Mr. K. Jamal, and council petitioner states that there is an instruction from the writ petitioner not to proceed this writ petition. In view of such statement, writ petition stands closed. Interim order, if any, stands vacated. Liberty granted to approach again, if so advised.
52 for admission.
Yes, Mr. Sharma. What kind of post? No, what kind of post he was holding? Where is the appointment order?
Yes.
Your file affidavit. Have you got a copy? You have already filed. But why didn't you give copy to the petition? So there's a difference between filed and being filed. Which of the two to accept? Being or filed? Mr. P.J. Phukan, Land Council correspondent K.K. Handy State Open University states that the affidavit in opposition is being filed in course of the day. List on so along with the affidavit. In the meantime, the writ petitioners, if so advised, may file a reply. Yes, madam. Use copy and audio several answers. Judicial order on that. Copy.
53 orders.
53 years. Service complete. Have you filed affidavit? You want to file? Mr. S. tasked counsel for a hearing phase 4 weeks time to file affidavit. Prayer on this 4 weeks. We want to file. Mr. Your name, sorry. UB Sharma for responding number 3 and 5 also makes us accepted. Interim is till today. Early interim order
9th October. Identity
who appears? SMT Chisti for secondary. He's praying for the interim order. Yes. 33. What kind of interim order you want? Sorry. 61. Interest of public service order Anjana Bora. Who is Anjana Bora? No, who is it? Private respondent. Years of temporary is allowed to be in charge principal of the same school. So where is the seniority list? 30? 33.
I'm getting one of the state of place from.
Just thank you. Petitioner is so 33 and 34 has to be read together. Okay. You are Obhijit Bora. Obhijit Bora. Petitioner, and you are R4. Just now, what do you want to show?
My date of birth is
30 12 1993.
and she is getting one from 5/9/1998.
So, yeah, so you are senior.
And mother, she has come to this school on transfer remark for the last part on 3/11/2020.
Where is your statement on her own interest? Third, Mr. B. Pro. State. Two good clear grounds. If it is untenable in law, just because a man this way or that way makes it, that doesn't mean the person will continue. Because once you allow this person will continue, this hearing will never take place. See, ensure that the service period is over. But if you stay, it's a reverse. Immediately they'll come for getting that. Heard Mr. B. Professor and counsel also heard Mr. SMT Chisti, the also Secondary Education Department. By the order of 5/8/2023, it was provided that the interim order would be considered on the next returnable date. According to the matter is listed today. And Mr. B. Purokaisal and counsel petitioner urges upon the interim order to be considered. The petitioner is agreed by the order dated 25/4/2023 of the Director of Secondary Education Assam, by which the respondent number 4, Anjana Bora, was allowed to be the in-charge principal of the Tejpur Academy Higher Secondary School, Tejpur. The petitioner asserts the order of in-charge principal on the ground that, as per the Annexure B, page 33, comparison of particulars of the petitioner and the respondent number 4, the respondent number 4 have been receiving the graduate scale of pay from 30/12/1993, whereas the respondent number 4 has been receiving the graduate scale of pay from 5/9/1998, and therefore, as a graduate teacher, the respondent number petitioner is senior to respondent number 4. It is also pointed out from the remarks column of the comparative statement that the respondent number 4 had joined the Tejpur Academy Higher Secondary School on 3/11/2014 on her own interest and not in the public interest, and therefore her seniority in the school can be taken note of only from 3/11/2014, and from such point of view also the petitioner would be senior. In the absence of any other criteria to be the in-charge principal, the best guide is contended to be the seniority of the rival candidates. As the petitioner is expressly found senior to be to the respondent number 3, the order of impugn dated so and so, allowing the respondent 4 to be in charge principal of Tejpur shall remain stayed until further orders.
Correct.
List after 4 weeks.
Timing again.
What was it?
I
Item.
know that medical admission, that Shulman committee is private adjustment.
For that one, we.
That one is, no,
Oh, this is tribal affairs.
I just, I thought some time by that because the Shulman committee, they are just getting it. So I don't, the 30th is
Huh.
the admission. So I don't, we ask that, I don't.
Choosing
29 mileage before the time will.
29 will be too late. Suppose something goes wrong, then we won't have any more time. Let it be sometime in the around 20, 22, 23, around that time.
I 25.
25.
Oh,
Stated by Mr. R. Dhor, Land Council for which department, Mr. Dhor? For the Tribal Affairs Department, that the committee concerned is examining the what? The certificate of the petitioner, and the final decision will be arrived very shortly. In view of such submission, list constraints.
Since that secretary is gone today, for medical leave, for operational, I will just indicate that the principal secretary will ensure that.
It is stated that the secretary of the department has gone on some personal leave. In view of the above, we provide that the committee shall now be headed by the principal secretary, which would be otherwise available, so that the determination is not deferred. Service upon whom? You are appearing. That's okay. Mr. MP Sharma, Land Council, enters appearance for respondent number 3 and prays for 3. 3 is time to file appeal prayer law this after 3 hours. And one more will remain, I think. No, 3. Only 3 or one more is there. 3 and 4, I think. We appeal for 3 and 4. Yes, Mr. Pai. Let him interact and tell us if he's the person. No. Let him interact with him here itself. And
In fact,
and tell us whether he is the person or he is not the person. See, only concern was when you raised, because later on this person comes and appears before the court and say, I am the petitioner. You raised an apprehension whether this person, he himself is the proceedee or somebody else. So let him examine this and tell us whether he is or he is not. So he is somebody different or the same man? Same person. So let him go and appear.
while visiting my family friend away from the house.
When?
Prior to as per direction of Mr.
Understand. So if that is so, but ultimately what is it? He should appear, answer to the tribunal and prove his case. The rest of the things are, these are not any penal offenses or anything as such. That you did this earlier, so now you cannot appear and prove your case. Nothing like that. From appearing. Yes.
Directed by more strict action.
See, initially it was little serious because one learned counsel who appeared earlier comes and tells before the court that this man, even I have not seen this man. It's only somebody came and handed me over the brief and I filed it. So of course, one thing we did not ask him, it would have been a little embarrassment that how did you get the affidavit done? That's why we didn't ask him, but still, that was a little serious. So we definitely, if somebody is playing with the system, a more stricter order is called for. That you do anything but get the hold of this man. Next, there is a change of counsel, and the says that yes, here I am. I'm ready to go and appear. So the order. Last occasion, you raised the apprehension whether the man who is filed and the man proceeding, whether they are the same or not. If I heard from the side, say they can come in. If they're interested, they can very well come inside. And not to stand there like that, peeping. Who is there outside? If he is interested, he can come and watch the proceeding. No difficulty. So, what order will pass? When the matter was heard on When the matter was heard on 31/8, was heard on 21/8/2023, Mr. J. Payam, Land Counsel for the respondents in the Home Department, had raised an apprehension that a person who may have filed the affidavit before the court, stating that he is willing to appear before the tribunal to prove his citizenship, may or may not be the actual proceeding that the respondents intend to proceed. In the circumstance, we require both the writ petitioner as well as the concerned police official to remain present in the court so that they can verify with each other as to whether the person appearing before the court and the intended proceeding are one and the same person. Your name? Who? Sorry, both of you are speaking. One of you say. T-A-G-U-L. Togul. Togul Boro.
Inspector Togul Boro.
Togul Boro is present before the court. So is the writ petitioner, Amin Hussain. Upon interacting with the person present before the court, Sri Togul Gogoi, Inspector Boro, has stated before the court that the person present before the court is in fact the intended proceeding. As the proceeding has himself appeared before the court by filing an affidavit that he intends to participate in the proceeding, accordingly, one order we already dictated with Janita. I think appearance date will be a little different. The person presence of the inspector Togul Boro as well as the petition disposed of accordingly.
I think so for admission.
Yes. Ah. Yeah, do you have those some of the orders declaring citizen? Let us see. Same thing. You describe the materials for the reason discussed above, no discussion. Here. Right. For reason discussion, evidence or found to be not sufficient and trustworthy procedures. And that's it. So this is one declaring to be a foreigner.
Yes, the first one is declared.
Next one. Mr. Pai, the first three we have gone through are orders where a person is declared to be a foreigner. And it appears the member is trying to use some over intelligence, which is not required. We are apprehensive that for declaring to be citizen, you are not giving any reason. So we wanted to examine that. So she has very wisely given three orders where she declared to be foreigner. There also no reason is there. As if to give the impression that this tribunal declares person this way, that way without reason. So there is no infirmity in it. Sorry. No, three I have gone through. No reason, even for declaring a foreigner. Let me go to the fourth one. Fourth one is also same, Mr. Pai. Sorry. Same. Where it is declared to be a foreigner. Again, fifth one is also same.
Miscommunication might have hidden. So they have sent
And we don't want it of one particular member on a random basis.
I have put it ahead.
On a random basis, anybody's order you can place.
I can bring
It's not that we are trying to
this. I have
just examine one member and
numbers of it.
sixth one happened to be a citizen. See, this is where we are trouble. First, you describe the documents. Let me appreciate. Projected. Ultimate thing from the record, it appears OPS projected Khalek as his father, whose name appeared in projected. And everybody projects. So if when everybody is projecting, we should allow every reference has to be allowed. Determination is whether the projected person is or is not projected as so and so. OP's name appeared. It has been observed that OP's name along with father's name appeared jointly in the voters list of 97. Strangely, 66, 70, 97, 2008 voters list are accepted. But there is no mention, this is a voters list of which village. Whether it's the same village or different village, that mention is not there. OP projected Khalek, whose name appears in 66 and 70. Then in 97 and 2008, OP's name jointly appears along with father. Thus, by the above two voters list, OP established a link with his father. 5 is stated to be periodic patta. 6 is an order judgment declaring OP's father as citizen. Thus, by the above order, could establish. Do you sincerely tell us, do you feel it is sufficient? Was the burden discharged? Suppose I take this one to be a standard order. Then we have to allow every petition. Every petition invariably a 66 voters list is shown. Somebody is projected. Along with the projected name, the name of the proceedee also appears in some subsequent voters list. Immaterial to which village the voters list is. Then one Khirasmi ID Patta. No one knows of which village where the land is there. And 6 is a judgment dated declaring OP's father to be a citizen. Enough. Village is same, and whether the order declaring OP's father to be citizen, whether itself is a reason order or not. Khirasmi ID Patta, where is the land in which village? Then whose name it is? These are the what do you do? So now, if I compare this standard adopted by this tribunal and the standard adopted in the matter here, what is the substantial variation? Here, everything is discarded. Even a Jamabandi is discarded, that you did not bring the original report. At least it has to be the same village. Where is the relevance of a document pertaining to land? When you see that X's name appear in 66 of village, say A village. In that A village, there is also Khirasmi ID Patta. Khirasmi ID Patta is no use because it will be in the name of X. You will have to show that you are the son or daughter of X. Jamabandi may have relevance because it will show the inheritance and mutation. But that again has to be in the same village. If the mutation is in B village and the 66 voters list in A village, nothing is there. So unless you spell out, sorry. So then, how the same tribunal over considered in another matter? Understand? How the same person over considered everything in another matter. This is the difficulty. We can tell yes, madam, both you are sitting behind. How many matters you have? 66 voters list, somebody's name is there, 70 it is there. Irrespective of the villages, doesn't matter. 1997 you have, 2000 you have. You also have a Kheras Patta of the 66 man and try to prove that you are a citizen. How many matters you have? quite a number.
Yes, sir.
So all those matters have to be declared to be citizen if I follow this. Why you are taking the extra burden of making some further inquiry then? It's it for another day for this matter. Put something on this. Mind you, we are not on tribunal specific or matter in general. Sorry. I can do it, we'll keep it also. So here also every discussion projected Shashi Mohan Burman to be the father. So wherever the name of Shashi Mohan Burman appears, it is stated. Thus on evidence coupled with the mention of it appears to be trustworthy. And come to a definite conclusion that the parents are Indian. Where is the finding that this man is the son or daughter of that man? In most of the cases, the father, person who is projected a father, he is a citizen with no difficulty with that man. Difficulty is whether you are the son or daughter of that man. So now if you discuss only your father and say no trustworthy, everything in this thing, just take a look, you'll come back and tell us. Want to put this thing a little, put it in order. That's it. And if a huge numbers have been declared citizen in this manner, then it is a matter of concern. We should take some decision on that. It's not to reprimand anyone on this time. That's on the purpose. Yes, sir. Yes. Mr. G. Fine, when Council of Department has produced some orders of a given tribunal, where some have been declared to be citizen and some others have been declared to be foreigners. In order to enable the court to understand the pattern in which the pattern of the judgments that have been rendered. Some more such judgments declaring persons to be citizen may be produced on a random basis on any of the judgments. It will be good. Can you get it by tomorrow? Tomorrow, our Lordship is having a single bench. It will be easy for us to fix this bench. Otherwise, division in another court. So there it is difficult to fix. So if you can get it by tomorrow, we can fix it tomorrow. Tomorrow, the single bench list is already out. If not, day after tomorrow. No, then again, studies in Guwahati or some other place that is unsure. So then it will be delayed, much delayed. Just get some sample orders wherever you have. That's all. And if somebody is having orders with them, you can get it collected from here and there also. Not that it has to everything will come. We just want to see what is exactly done, whether it requires some kind of observation. That's all. Tomorrow or day after. Just again on the day after. Mr. Krishna and Mr. Nath, we'll take it up day after tomorrow. I think we have to dictate the order. Day after tomorrow, we'll take it up. Sorry. It has to be after 2 because the regular bench is over. Did you want Mr. Mehta?